Just coming here to just to speak to encourage our team to join, participate in Japanese negotiation competition. Therefore, I feel somewhat bad that whenever I see Professor Morishita, it's simply his coming here, going out of his way to come here, and then he has to fly back, take the train back almost immediately. So I hope we appreciate very much how the effort that he's taken just to be here today. But I won't say any more. I'll give the floor to Professor Nomura to talk about the use of principled negotiation in the settlement of disputes. Professor Nomura.
Thank you very much for kind introduction, Professor Reyes. I hope coffee, sandwich, and refreshments were good enough for you to come to this seminar. We appreciated your coming for the seminar. I don't know about the audience for today, but I see some faces like students and faces like professors. So you are students. And have you ever heard of principled negotiation? Who knows about principled negotiation? Raise your hand. Only one, two, three persons. Perhaps I may ask you to explain about the principled negotiation. Or I may ask you some questions. It will be boring if I keep talking for 30 minutes, for example. Okay, so my topic is here. What is principled negotiation? And I'd like to talk about an amazing grace revelation. Do you know the song, An Amazing Grace? Who knows? Can you sing? I won't sing. The room is not karaoke, so. But it's about a man who did wrongs in his past, but he repented and found a new way. And I was such kind of person in 1985 when I studied at Harvard and took negotiation workshop there. Until that moment, I was boasting about my skills about argumentation, debates, and I used argumentation in negotiation. And argumentation is like litigation, a court proceedings with a judge or judges, like Professor Reyes. And people are very, very adversarial, the plaintiff and the defendant and the judge or judges. And if I win, you lose. This is a zero-sum game, not win-win situation. It can be said this process is very positional. My position is here. I like to protect my position. And I am justifying by using argument or skills which and we were taught at law schools to justify our position, and your position is wrong. Your position is proved to be wrong. So you have to make concessions. This type of negotiation, it can be called a positional bargaining. And positional bargaining is zero-sum game. But at Harvard in 1985, they were teaching principled negotiation or interest-based negotiation. And as a new man, reborn, I wrote an article about that experience, and I began to teach principled negotiation at Osaka University. This is the table you find in a famous book in Getting to Yes. So some of you might have read this book. And this table tells us that there are soft ways and hard ways to negotiate. And either soft or hard, it is positional. Even if it's soft, they believe participants are friends, and the goal is agreement. So they want to think that we should reach an agreement. That's the position. My position is here, hard. Participants are adversaries. The goal is victory. I win and you lose. In contrast, the principal negotiation, the characteristics of the principal negotiation are listed here. The essence of principled negotiation is to think that participants are problem solvers. We get together and sit down and attack the problem together. We are solvers. And you are not the problem, and we are not the problem, but the problem is here for us to solve together. Oh. So the goal for the principled negotiation is a wise outcome reached efficiently and amicably. And here are some of the points or guidelines to characterize a principled negotiation. Number one is separate the people from the problem. And number two is focus on interests, not positions. I will get back to this number 2 point later. And number three, invent options for mutual gain. I'll deal with this point later. And fourth, insist on using objective criteria. And at Harvard, negotiation workshop for the third term, beginning from January and continues for 1 month from 8:50 to 5 o'clock. And perhaps after 5 o'clock, we do negotiate in teams and groups. So for a month, we are taught to utilize these 4 guidelines. It's very, very difficult. And sometimes we discovered after many trials and errors, and after the failure of the agreement, we found that there's one person who is the problem. And if he is there, any negotiation would fail. And fortunately, that person, the problem person, discovered that he was the problem. After many negotiation trials, we'll have feedbacks. And any negotiation, whenever he is there, the agreement was never reached. And that's exactly he discovered for himself. So I hope he improved his attitudes towards negotiation. So sometimes in real life, number one, separate the people from the problem is impossible. But the principal negotiation teaches us to try to separate as much as possible. There are many situations that the people is not really the problem. It's a matter of perception or recognition or cognition. It depends on our biases against people, that the problem with this negotiation is not the substance, but the people himself. Or the other side is the problem, is the bias we tend to have in any international negotiations. It happens very often if our backgrounds, cultural, historical, are different. Now, let me go on to the next slide. We discussed 4 guidelines or 4 points. Now, they talk about 7 elements of negotiation. And when I was a student, we are taught that the important points are 4. As young as he is, Professor Morishita was taught at Harvard, 7 elements. Important points are 7, and they are elements of negotiation. If there is a negotiation, there should be elements, 7 elements. And what are the other 3 elements? They are number 5, prepare a better partner. In the first edition of this Getting to Yes, there is a discussion about partner, but they are not so stressed. But these days, the partner is considered to be one of the 7 elements. And number 6 is to make a carefully crafted commitment. Now, this is a very interesting point here theoretically, but today I'm not talking about theory, I'm talking about theories on the day after tomorrow, March 3rd seminar. But to put it concisely, here are 2 interpretations. One is to make a carefully crafted commitment means to make a credible commitment. That if you make a commitment, the other side could rely on you. And if I offer something, the offer should be firm. And if you say, I accept, the deal is done. So making a credible commitment means number 6, make a carefully crafted commitment. And the other interpretation is like a good lawyer to make a legally binding commitment, to draft your agreement as firm as possible. So like a game theory commitment interpretation and legally binding commitment interpretation. There are two interpretations for number 6. That's a very interesting theoretical point. Now the last point, 7, is secure a good communication. And here, active listening is stressed. Listen actively and acknowledge what is being said. Even if you do not agree what is being said, you will show that you are listening and you are understanding what the other side is discussing. And speak to be understood, not speak for yourself. Speak to be understood. Now, that's for 7 elements of negotiation, introduced in 2005. And now, these 7 elements were referred in this 3rd edition of Getting to Yes, published in 2011. Now, I'd like to talk about quarrel over an orange. This is a well-known anecdote. You can find the story in Getting to Yes. A quarrel between 2 sisters. But to make a script for the DVD, introductory DVD for negotiation, I changed the situation to put gender balance consideration. And I make it a quarrel between a sister and a brother. And may I ask us students to read? Would you like to read the script? You can be a narrator, and who's going to be the brother? Yeah, you can be the brother, and a sister. Okay, are you ready? Would you mind standing up to show, like actor and actresses? To show.
Red button by your microphone. You press the button, you'll see a red light come on. You'll be all louder from that.
Yes, you can just stand up and show yourself to the audience.
Okay.
Anthony can start.
Okay. A sister puts an orange on a table and is starting to do something. And her brother comes in.
Oh, an orange, lucky.
No, Mom gave it to me.
You're keeping it all for yourself. It's not fair. Give me some.
No.
The argument continues.
You are mean. You can give me half, can't you?
If you insist, okay, only half.
What did they do with the orange that was cut in half? The brother peeled the orange and threw the peel into the trash can. He only ate the fruit of the orange. The sister peeled the orange and started to shout the peel. She wanted to bake a cake with the orange peel. What the sister wanted was not the fruit of the orange, but just the peel. This peel over an orange teaches us many things. What would have been the best way of negotiation for them to obtain a more satisfactory result for both of them?
Thank you very much. No, this is a very simple story. And sometimes we make fun of this kind of story. It's for kids. But in fact, we don't usually understand the implications of this story. So I'd like to touch a little bit about this story and analyze the story. What can we learn from the orange case or the orange dispute? Now, two of the seven elements appear here. Number 2 element, focus on interests, not positions. And number 3, invent options for mutual gain. And it's very difficult to understand the distinction between positions and interests. But if we use this orange dispute, it's easier to explain. They are arguing over the orange. This is mine, or this belongs to mine. No, this should be mine. And they assume that there is only the orange now. And if you get the orange, I lose. If I get the orange, you lose. So this is zero-sum game. And this is a positional bargaining. And the position here is the orange, or the ownership, or the dominance over the orange is debated, arguing. Two sides are trying to justify his or her position, positional bargaining. Now, if we focus on interests, not positions, the scene will be changed. But what about the half solution? I'll give you the half part of this orange. Now, you discover that the half solution is not satisfactory, not 100% satisfactory to the sister and to the brother, because they could have obtained the whole orange, but they ended up with the half. And about the interests of the sister and the brother. The interests of the sister is to bake the cake using the peels. She is not interested in the fruit. And the brother is only interested in the fruit. And so he threw away the peels of the half orange. Consider the interests. We could invent options for mutual gain for the brother and the sister. Now, let us analyze the case further. Solution A is no negotiation, the current state of the society. The sister has kept the orange all to herself. So the sister's satisfaction is 100% here. And the satisfaction of the brother is 0. And if we assume that this society consists of two persons, the brother and the sister, the total level of satisfaction of this small society is only 100%. How about the half solution B? They negotiated and divided the orange into two parts. The sister got only half the pills she wanted to use, so 50%. And the brother, he could have won the whole fruit, whole orange for himself, but he ended up with a half. So 50% satisfaction. 50% and 50% is 100%, the same as solution A. So solution B doesn't change the situation, doesn't change the current status, no development. And solution C, they negotiated, discovering the interests and combining the interests to come up with the options, and divided the orange into fruit and peel parts. So the sister got what she wanted, the peels, 100%, and the brother got the fruit, 100% satisfaction. 100 and 100 is 200%. And this state of the affairs is better than the current state of the situation. So the society has improved itself. And this is the purpose and the function of the principal negotiation, especially the element 2, based on interests and invent options. Now, as I told you, I will discuss the Pareto improvements on the seminar scheduled on March 3rd, and I'm not going into the details. The last one is reference, and some of you may be interested in reading in Japanese, so I put my Japanese article written in English, no, in Japanese. And number 5 is the DVD. It's very simple and easy to learn how to negotiate. So please challenge if you are interested in negotiating in Japanese. And how can we utilize these 7 elements, the elements of the principled negotiation? It's up to Professor Morishita to discuss about. So that's all for my part. Thank you very much.
Okay, thank you. Yeah.
Okay, thank you for joining today. My name is Tetsuo Morishita from Sophia University, and I'm a member of the steering committee of this competition. Today, I'll try to introduce some secrets, hopefully very useful secrets for better negotiation, and I myself learning from the experience of coaching or organizing this competition. Before I enter into the detail of such kind of secrets or technique, I think that it would be better for you to understand what is competition. So I'd like to make a brief explanation about the competition, and after that, I'd like to show very briefly about 5 or 6 minutes a negotiation round, or the digest of negotiation round of the competition in 2013. Okay, please look at the first slide. It explains briefly. The competition starts in 2001, and it's a 2-day competition held at Sophia University, Tokyo, and it's an annual competition. And this year, 2016, we have the 15th competition, and the 15th competition will be held on December 3rd and 4th at Sophia University. And in 2 days, the first day we will have arbitration, mock arbitration, and the second day we'll have a negotiation. On both days, a program relates to the cross-border business negotiation by hypothetical fictional companies in Arbitria comes from arbitration, and Negoland comes from negotiation. In the last year, 14th competition, we have 15 leading Japanese universities and the University of Hong Kong and Team Australia. Team Australia consists of 4 leading Australian universities and National University of Singapore. And Reyes Sensei mentioned the last year, National University of Singapore got the first prize, and Sophia University couldn't get the prize, so also, our university is very, for the next year, we'd like to get our best and improve the performance. Okay, let's see.
Round B. Negotiations took place the following day. In Round B, participants performed negotiations over M&A in which Blue Corporation intends to purchase Red Corporation's subsidiary, Red Chocolate. Specifically, the negotiations were held on 5 issues, namely the selling price, the treatment of management and employees, representations and warranties concerning soil contamination, representations and warranties concerning transactions with a third country, and breakup fees. The University of Tokyo and Chuo University begin a match in Japanese. First, the parties explain their negotiation strategies to the judges. A match in English is held between Tohoku University and Osaka University.
I regard not just the purchase price.
Also, you want to make sure before starting before negotiating each topic.
As a whole. Just because
the possibility of the contamination by former owner is not zero, even though we conducted some survey.
You to represent and volunteer before you possess the land. Have you ever invested about the land you possessed? Have you ever?
It's no problem if we keep.
This is another match in Japanese. The participants are from the University of Hong Kong, who participated for the first time, and Sophia University.
違反があった場合には、そのレッド社のですね、本社がですね、規則性の有無にかかわらず、汚染で生じた浄化費用については、全額負担していただきたいと。で、大体この請求期間については、5年ほどを見ています。
記者の、このような提案をなされた目的としては、基本的には浄化費用については、弊社が全額負担してほしいという意向がある。それ以外の何かしら理由というのがありますでしょうか。基本的にはこちらが全額負担するという形であれば、もしだから、言い換えると、ブルー社が。
The participants are from Kyushu University and Waseda University. The negotiations are getting close to an end.
我々としては全面的に保証させていただくということで。
調査終了後からとしてしまうと、どうしても4月から5月末までの空白期間が全く保証されないということになってしまいますので、当社に、だいぶリスクが高いということで、この期間についてもしっかり保証しようという。
ブレークアップフィーについてのところと、データ国、それから土地に関する表面保証に関しては、今の段階で合意させて。
そうです。
社の内容をまた多少考慮することによって価格をもう少し上げるといったことは可能なんでしょうか。
弊社といたしましては、やはりその企業価値を考えて、そこから表面保証していただいて、リスクが軽減した分、少し価格を上げるということは考えております。
A match in English held between Gakushuin University and Kyoto University. Each team makes a self-evaluation and replies to the questions of the judges.
How did you get comfortable in taking on such an unknown liability?
It was one of the points where we would actually make, where we would,
He felt that we were rushed into that conclusion. So if we were good cooperation, maybe we can move on to the next topic, and then we're gonna make a conclusion at last.
So what do you think of the scale?
I thought it depends on time how they.
Finally, the comments from the judges.
It's more about the style. I observe sometimes one speaker saying like 8 times within 30 seconds, and as I'm saying now, it's easy to say, but it's easy also to make the habit of using to make a pose, but you might want to be self-conscious about not using as much as possible.
How they should take it. Because if you accept the procedure, no, sorry, that's your risk, too bad. It'd be very difficult to drive you back. Likewise, if you accept land, this contract happens or doesn't happen, your risk, you have to deal with it. And if you hadn't started with that point, then you could have swapped them at the end or left them. Understanding risk and how you manage risk is a key aspect of what you do as a lawyer. The bankers advise on price and valuation. The role of the lawyer is more to understand and apportion the risk of the transaction.
It was also really good to making clarification to other parties to try to figure out what their real concern is. I think that was a really good point. Lastly, when making some compromise, sometimes it was not clear how it is that compromise is reflected in the price of the share. Well, thank you very much.
Thank you very much.
Well done.
Okay.
I hope that now you get a better understanding about how the competition looks like. Okay, so let's move to the content of my presentation. First issue, the title is Better Negotiation. So a secret for better negotiation. So first issue I have to talk is what is better negotiation? But as you may easily imagine, it's a not easy question. And in fact, every year after the competition, we got feedback from the participants. And some participants says, some participants who participated the 2 consecutive years made such kind of statement. The last year, we did one way. We did such a way. And the judge said, you should do it differently. You should do in such a way. And following the next year, this year, they followed a judge's advice. But this year's judge said, oh, that way is not good, and you should do differently. This means that, as you saw in the video, there are various judges come from various backgrounds, and the judge has various experience. So from their belief or experience, judges may have some different perception. What are good negotiation or better negotiation? But from theoretical viewpoints, I, as an advisor, could say that at least these kind of five things could not be a kind of precondition or essential requirement for the better negotiation. That is, reach an agreement, distribute 50-50, or make your counterparty accept your proposals, follow the preset agenda and schedules, amicable atmosphere, well, there was no fight. These kind of things could sound very good, but these things could be results of the good negotiation. But as Professor Nomura mentioned, the better negotiation or good negotiation is a negotiation which follow the principled negotiation. For example, if you think that reaching agreement is very important, the counterparty could easily manipulate you by insisting hard proposal and give a threat for the break of the negotiation. By doing so, your counterparty can easily manipulate. And also for you, the amicable atmosphere is very important to be a good negotiation. The counterparty, again, could do that very hard, could manipulate the negotiation by pushing so hard. So please forget these kind of elements from your criteria for the better negotiation. Rather, I think that you should use a principled negotiation to find a better way. In relation to the competition, we have this kind of evaluation form. I can distribute. May I distribute? No. Sorry, I should have brought more. Okay. Yes. Yes, this is the evaluation form, and there's 15 items. And this evaluation form is a message from the steering committee. What the steering committee considered the better negotiation? What kind of elements is important to be a good negotiation from the steering committee's viewpoint? So if any of you consider to participate the competition in the future, you should read this criteria very carefully. If you did very well in the different other aspects which are not covered in this criteria, judges will not be able to give points. Okay. So, for example, it says that reasonable setting of objective goals for negotiations is important, and appropriate setting of a strategy to achieve the objectives or goal are very important. Also, constructive proposals, effective and persuasive discussion, communication, principled negotiation, partner, and outline of the agreement are important aspects of the good negotiation in the competition. I'd like to make some comment. One, probably, from my viewpoint, it is my understanding one of the most difficult elements for the especially undergraduate student is the last one, outline of the agreement. This element is, with this element, participants are requested to memorize the agreement, what they have agreed in writing in some way. So, the participant may write down their agreement in whiteboard or use a PC. It is up to the participant's choice, but participant has to write down or memorialize what they have agreed in text. But especially for Japanese participant, this is very difficult because in Japanese law department, such kind of educational training has not been rarely made to undergraduate students. But from the viewpoint of judges, practitioners, writing to memorialize what they have agreed accurately are very important. So in the past competitions, they didn't have sufficient time, so they rushed to write down the memorandum. As a result, one party add something which both parties had not agreed. But the counterparty could not find out that point, and they signed, okay, it's an agreement. So it means that from judge's viewpoint, both parties did very bad on this element. The one party did bad by adding something which had not been agreed. But from the other parties, they did very bad because they could not find, or they signed the agreement which contains what they had not agreed. So this is a very important point. And if you had a good training, you could improve for this element criteria. The next slide. One thing almost all judges stress, what is important for good negotiation or better negotiation is a preparation. We invite lots of practitioners from business field or diplomats or lawyers, and we had a lot of, sometimes we ask lectures from such experienced negotiators. But when they make such kind of lectures, all of them stress what preparation is important for the successful negotiation. But it's difficult how to prepare. How to prepare for better negotiation is also not easy question. But from my viewpoint, I think that first thing you should do is understand your company, understand the counterparty, and understand the market, and understand the negotiation itself. Students, from my viewpoint, students tend to put too much focus on the problem, read the problem, and try to find some answer from in relation to the problem. But I think before that, students should use more time to understand your company or counterparty's company. For example, in the last year's competition, Red Corporation is a real estate company. The Blue Corporation is a financial institutions. First, they should spend much time to understand what is a real estate company's business and what is a financial company's business. And last year, the negotiation rate to the development of some area, special economic zone. So they should spend the real case of such kind of development, and they should understand what kind of issues occurs in relation to such kind of development. By doing so, students or participants may understand the interest of the parties, or they can more easily create various options, and option which is a realistic option with such kind of basic understanding regarding the company or counterparties or market. So I think that one of the important steps is to study the market or real world before entering into the details of the problem. And also, when you prepare, I think that using 7 elements would be a useful way to make better preparation. And actually, the 7 elements is developed in Harvard to offer the good framework for better preparation. So, for example, as a first step, you should think about what is your and your counterparty's partner, and what is your and your counterparty's interest. What kind of options may be considered which would satisfy both parties' interest? Is there any standard which may be used? What kind of statement and questions should you make for better communication? What is the relationship of the parties, and what is a possible commitment, possible final agreements? By trying to answer these kind of questions as a part of preparation, I think that your preparation becomes more principled, not a case-by-case or ad hoc type of preparation. I'd like to add a little bit more explanation on this point. Regarding partner and interest, in the competition, each parties are provided general information and also confidential information for your own company. So you have some kind of information regarding your partner and your interest. However, you don't have any information regarding the counterparty's partner and the counterparty's interest. It's also the same in the real life. So, however, in principled negotiation, your understanding about the counterparty's partner and the counterparty's interests are very important. So, as a part of your preparation, you should estimate your counterparty's partner and the counterparty's interest. You could only guess, but try to guess as much as possible, as better as possible. And during the negotiation, face-to-face negotiation, you check your estimation is correct or not. by posing various questions. Is your company such and such? Or this one and this one, which is more important to you? Or this package and this package, which do you prefer? By making such kind of questions, you should try to find out what is the real interest of the counterparties. Of course, if you ask the counterparty, what is your partner? The counterparties will never answer. But so you should think about during the process of preparation, you should consider what kind of questions would be appropriate. Next, regarding the interest, I think regarding the interest, participants sometimes don't understand your company's own interest accurately. But probably it is also the case in our real life. Probably I myself feel that I would like to get something, but sometimes I don't understand why I need something. And I tend to focus on my position. I would like to this one. But by making better preparation, you should understand your own interest. How you can identify your interest, real interest, is ask the question, why? Why this is important? Why you need this? Why? So by doing so, you could find what is essence or the core of your requirement. This is your interest. By identifying such kind of your own interest, you could make a principled negotiation, not stick to the position, but focusing on interest. And also, in competition, always there are civil issues to be discussed, negotiated. And also in real life, people usually have civil interest. So the next step is to consider the priorities between interest. Prioritize. One textbook prepared by Harvard negotiation project says that you should prepare some kind of scoring system. This element has 5 points. This element has 3 points. Represents such priorities. Well, with such a score sheet during the negotiation, you can easily compare which kind of bargaining is satisfies your interest most. Next, communication. Also, some research says the first 5 minutes is very important for every negotiation. In first 5 minutes, the counterparties have some kind of perception regarding your counterparties or the mood or atmosphere of negotiation. First 5 minutes. So how to start the negotiation is very important. So, but students didn't have such kind of idea and enter into the start the negotiation without preparation. But as a part of preparation, how about considering how to start and how to spend first 5 minutes to set up the atmosphere or the mood of the negotiation. And also, as I mentioned, I recommend that to prepare the list of questions. What kind of questions? Not only the content, but also the manner. In which kind of manners or which kind of wording you are going to make questions. By wording, counterparties may feel it's a little bit annoying or it's a little bit dangerous questions to answer, or the parties have a good feeling, and some questions may give the impression that it's a good question and I should answer to that question. So not only the content of the questions, but the exact wording or exact wording is also important. So you should spend how you should express your questions. Finally, commitment. Regarding the commitment, I recommend that participants try to write a draft contract, which may come after the negotiation. As Nomura Sensei mentioned, the commitments as the result of the negotiation needs to be clear and specific. However, students is very bad on, usually the students are very bad on this point. For example, the parties make an agreement. For example, blue corporations will do something. For example, will pay $1 million US to red corporation. That's all. But in real life, such a kind of simple agreement is very vague, very unclear, and very unsatisfactory. For example, when blue red corporation shall pay, the timing is very important. If there is a big difference between the payment today and payment in 1 month, or payment after the counterparty do something, so by writing a draft contract, probably you may find which kind of elements should be discussed in relating to some kind of item. Also, again, details are very important, I think. So I mean that at the very beginning, Reyes Sensei mentioned that sometimes in negotiation, apology could be an issue. Also in the competition, and sometimes in the past competition, the problem says red corporation requests blue corporation to apology their bad faith or their bad acts. Students tend to focus on if blue apologies or not. But the details are important. I mean, who apology? When apology? Where? For example, blue corporation goes to the red corporation's head office and make apology? Or there is some kind of apologies in the neutral place or some kind of the business meetings. It's a very big difference. Or written apologies or oral apologies, very big difference. By paying sufficient attention to such details, the agreement could be more realistic and there could be more room to negotiate, to reach a better agreement. So I think that details are very important. Also, I think that participants tend to focus too much on the substance of the negotiation. Substance is a money amount of what kind of things blue corporations do, or what is red corporation's liability, these kind of things. However, evaluation sheet lists other important elements for better negotiation. In fact, evaluation sheet itself doesn't say anything regarding the substance of the negotiation. Well, say very little regarding the result of the negotiation. So, for example, how to start or how to create a good atmosphere, a persuasive statement with reasons. Reasons, I'd like to add one comment regarding reasons. Reasons, to add reasons is very important to make your statement more convincing or give an impression that your statement is legitimate. There is some research result which showing that simply asking something and even the reason is nonsense reason. When a party makes some request with reason, the counterparty feels the impression that such request is legitimate. There is a research result. And in fact, I had an experience that I served as judge on for international negotiation competition by law student. When I made a judgment, the representative from Russia made a very aggressive negotiations. They took very aggressive negotiation style. But what was very impressive to me is that that representative add reasons every time. I think this is a good price, very high price. But they add reason because such and such. So try to add reason to your statement. And the second one, listening is very important. In order to make principled negotiation, your understanding regarding the counterparty's partner and the counterparty's interest is very important, essential. However, you are not able to know counterparty's partner and counterparty's interest in advance. So what you need to do is to ask questions. So there is a study that good salesperson spend more time to asking rather than talking. So by making various questions, they understand the counterparties better, and it will result in the better sales result. Okay. And this one is actually the Nomura sensei's mentioned, and effort to create value by making use of the difference between the parties. The difference is the source of the value creation. If the red corporations and the blue corporation have totally the same interest, it's very difficult to create value. This is what Nomura sensei mentioned using the case of orange. If the brother and sister has both brother and sister want to make a cake, orange cake with a pear, it's very difficult to create value. But the difference of their, ideas or needs was the source of the creation value. Okay, and the final point, teamwork. Teamwork is one of the elements of evaluation. In the past competition, one judge came to me and said that that negotiation was wonderful because in the negotiation round, each participant takes some role, such as vice president or head of legal department or head of business department. So the judge said to me, the student taking the role of vice president behaves like vice president. The students of the legal department role behaved like legal department. So such kind of combination of role gave a very good impression to judges. If vice president talk too much or head of legal department enter into the accounting matters or business matters too much, probably the judge feel that this teamwork is not so good. There is a not so good, role distribution or the distribution of responsibilities. So this could be by paying some attention, you could get a better result on this item, on these elements. But in order to, improve your skill or your performance from this viewpoint, practice and practice and practice. Practice is necessary. So I recommend that if some of you is considering to participate in the competition, practice is very important. Okay, so I'd like to add something. Regarding the process, I said that the students tend to pay too much attention on substance, but for negotiation, process is also important, how to start. And agreement of process should be made at earlier stage. For example, let's spend such and such time, and let's leave, for example, 15 minutes at the end of the negotiation to confirm, to check the written agreement. Well, this kind of process, agreement of process should be made in earlier stage. And also, information exchange stage should occur in early stage. And after that, after identify partner interest issues and create options, choose the best option, and make a clear commitment and written agreement. You should understand that in negotiation there are these kind of process, and you should understand which kind of process should be made earlier. Of course, sometimes you should go this, and again, you find that some more information is necessary, and go back to information exchange. That way we go such kind of go on back. But as a basic rule, you should understand this kind of process exists in your negotiation, and it will be better for both parties to share where we are. These two comment. Even though that you made a preparation thoroughly, always in negotiation something occurs, something unexpected occurs, because you don't know the counterparties exactly in advance. So someone says a negotiation is similar to jazz. And ad-lib is necessary, and the timing to enter into the, to make such an ad-lib is also important. And sometimes ad-lib may fail. If you make some statement in ad-lib with that your preparation, it may fail. It may don't work well, but sometimes you need to challenge. Okay, enjoy jazz. Also, I think that negotiation is similar to go game. So in the competition, negotiation continues about 3 or 4 hours. During such a long time, strategic pricing of pieces is also an interesting part. For in the very beginning, you should get some statement from the counterparties, and such kind of statement from the counterparty may become useful in the very later stage. I don't know how many of you play Go, but some concept of Go, such kind of feeling of Go might be useful to understand the dynamics of negotiation. The last slide. I'd like to pick up 5 items which I recommend not to do, avoid as much as possible. The first thing is try to control your counterparty or push your idea to accept. It's a bit dangerous, but in the competition, every universities make hard, thorough preparation, and tends to have the belief that our plan or our idea is excellent. With such kind of belief, they tend to push. Your company should accept our plan, which may be very beneficial to your company. Oh, you don't worry. Your company simply follow our plan. These kind of things. But such kind of negotiation doesn't work well because autonomy or independence or contribution to the result, to the agreement, are the important element for parties to get satisfaction. If you push your own idea too much, and the counterparties feel that, or I was forced to accept counterparty's idea, probably they feel less satisfaction. On the other hand, if the result of the agreement is a result of a joint work, or the counterparty feels I independently or with autonomously choose this result, they have more satisfaction. So this is important. The second is too amicable or too easy compromise. It occurs. It very often occurs. And also this is one of the weakest point of Sophia University's team. Sophia University students are so easily make a compromise, try to be nice to the counterparties. But the judges come from real society, feel some unsatisfaction on this kind of behavior of students. I don't say that you should push hard or try to be hard negotiator, but when you make some compromise, you should make clear that I'm compromising and you should get something in return. Okay. And also, the third one is too formalistic, enjoy jazz. I said, don't be too formalistic. And too abstract, general, and vague. This is what I have already commented regarding the commitment. And the final element, unrealistic commitment. The judges come from real world, so sometimes judges feel that the agreement, the content of the agreement is unrealistic. So I recommend that you, in the process of preparation, you should think about the possible commitment, possible agreement, and ask some advice from the practitioners or the one who knows such kind of real world. Okay, thank you very much.
We've run out of time, but Professor Nomura and Professor Morishita will stay on here if there are any questions. I will only say that when I was 17 years old, my friends invited me to attend the lectures of Roger Fisher. He was lecturing on resolution of international conflicts, and it was one of the most popular courses at Harvard. I didn't take the course, but I went with my friends to listen to some of his lectures, and they were extremely fascinating. He was talking about how possibly one might try to resolve the conflicts in Palestine. And he was using his methods, an early version of his methods, to try to show to the students how the conflict was not perhaps as intractable as it might seem. I enjoyed those lectures very much. They were quite fascinating. It was fascinating insight into Professor Fisher's theories. And I think this afternoon we've enjoyed very much the presentation of Professors Nomura and Morishita for the same reasons. Let's give them a hand. Thank you very much.